So for the next section, we'll be calling on Dr. Helen Chuma-Okoro for a section, and she'll be taking us on the theme, Building an Open Future, the State of the Public Domain in Nigeria. But before she comes up, I would like to read a bio, and also we'll be having a quick interactive section. It's nothing serious, just to ease the room. So Dr. Helen Chuma-Okoro is an associate professor at the Nigerian Institute of Advanced Legal Studies, specializing in intellectual property law. She holds degrees from the University of Calabar, University of Lagos, and the University of Cape Town. So before she comes up, I want to ask, I'll just say a statement and you tell me true or false. Okay, so now, the public domain, I know some of us, we saw this program maybe on the flyer, social media, or you watched the video and you came and like, okay, let me just come and get one or two for this program. So I'll be asking, the public domain, what does it mean? Does it mean that anything I find online is free to use? True or false? False. Okay, who wants to tell me why?
Please, I need the slides. This is me. It's me. It's not, she didn't send me to represent her. That's me. That's my social media picture. But there's a real Helen. Sorry? Which one do you prefer? Okay. I guess it's on the basis of my specialty in IP. We call it IP. That they invited me here to speak. But I'll try not to make this too legalistic. I'll try, I know we have lawyers here, but I don't think this is a subject that we have to, let's just break it down and be very, very practical about it. So, so they gave me a general scope, and I decided to couch this topic out of it. Opening the commons, legal and policy pathways for expanding the public domain in Nigeria. I know that's a mouthful, but we're going to try to unpack. So, how do I control that? The next slide. So I want to start by telling a story, and I'm sure most of us know that story. The story of King Midas. I don't know whether anybody is familiar with that story. It's one of these mythologies. It's not like something that happened, just like we have the Greek mythology. It's something like that. So what about King Midas? It's a story about the struggle between open and closed as it concerns information. So that's why I picked on the topic. The story, hoping that it will represent more closely what I want to discuss, and it will provide a background for me to delve into the real subject for which I'm standing before you. So the story of King Midas is one of those kings, like I said, is a folklore. It didn't really happen. So there was an incident that happened. I just want to shorten the story. And King Midas developed ass's ears. His ears turned to those of an ass. Now, it was a secret, closely held secret. Nobody knew about it because he was absolutely embarrassed about it. So he kept it to him. Fortunately, his baba, or the person that used to take care of his hair, I don't know whether they called them baba at that time. So the person discovered, and this information kept bothering the person. The person could not hold it. The person wanted to tell, the thing was bothering the person. It was consuming him inside. He needed to tell somebody, but he couldn't because he realized that if he tells somebody, it might become known to the society and the king will be embarrassed. But he couldn't sleep. He needed to tell somebody. So what did he do? He went into the field, dug a hole, and started whispering in that hole. King Midas has as his ears. King Midas has as his ears. So as he was saying it, he was getting some relief. So when he was done, he now covered the hole and went away, and he felt okay. Unfortunately, the grass started growing in that spot. And the grass carried a message and started whispering it into the air. And the birds picked it. And before you know it, people that could understand bird language, they started hearing the message all over the place. King Midas has as his ears. King Midas has as his ears. And that's how the thing became full knowledge to the public. Now, what's the essence of me telling this story? It's not because I want to entertain you. I'm not an entertainer. But to tell you the nature of our information, which is a very broad concept, information and knowledge. By nature, it is not designed to be closed. And if you attempt to close it, there is a problem. Now, think about yourself, or maybe not you. I know it happens to me. I won't pretend. Somebody tells me something. Oh, Helen, see you. This is it. Please don't tell anybody. Like within family circle, one of my sisters and I say, sister, see what is happening, but I don't want people to know. I'm just trying to sort it out, but I need prayers. And suddenly, the thing keeps like, before you know it, you call your other sister. I see you, But you ask yourself, you that were telling me not to tell somebody, what was pushing you to tell me? Information you can't keep, you want to share. So even you that needed it to be kept separate, you now want to put the burden on me. You tell me and bound me to an oath of secrecy that I shouldn't tell somebody. The same thing that was urging you to tell me is also urging me to tell somebody. And so I can't keep it. I tell my sister, and then that sister tell the other sister, and then before you know it, everybody is an open secret. Everybody knows, but the person that told me doesn't know that everybody knows. And it happened to me recently. I had an issue of prayers, but I didn't want to expose it to the family yet. And I told my very close younger sisters, but I knew, of course, that they would tell. But I still needed to, but I just warned them so that even if they are telling, they should restrict the number of people, but I knew they would tell. But when everything was sorted out, and they are now told them, oh, this is what I passed through, but I'm sure this is not strange to you people. So I was looking at the two I told, and talking to all of them. I know it's not strange. I know you must have heard. So they couldn't, because I put it straight, direct to them. So they couldn't deny it. The next thing one of them that I didn't tell said was, anyway, we thank God that everything is okay. So definitely, because they didn't know, they would have asked me, oh, what was it? But there was no curiosity on their part. So I knew, okay, this is an open secret. So now that is information. And information generally, like I said, it covers knowledge, it covers everything we know. It needs to be told. If you don't tell, if you don't share information, you kill it. How? Because if you bottle it yourself, we have a lot of disappearance of our traditional knowledge, which were bound by secrecy. Traditional medicine, for instance, people no longer are able to share their traditional knowledge in medicine because somehow they felt they don't want to release that knowledge. And if they don't release it, nobody will know. But if they release it, they're not guaranteed that it will be safe. So eventually they end up dying with secrecy. We have instances like that. So when you don't share knowledge, the tendency is that it dies. The other thing is that when you don't share knowledge, that advantage of revitalization, regeneration is lost, because when you share knowledge to people, the next person that is hearing that knowledge or coming to know about that knowledge can utilize it in a new way. And so there is improvement for the society. So that is why information by nature is designed to be shared. And so it loses its vitality if it is not shared, because at the end of the day, like I said, it will eventually die off somewhere. And then the opportunity of people to utilize that knowledge in a new way will be lost. Recently, I'll just give this example. There was this old generation musician, so Mike Ejara. This is somebody of, I think, his late blessed memory. The classics of my mother. It was very popular in their time, and then it trended for quite a long time, but in some quiet societies, and then it died off. And so one of these social media TikTokers one day produce a skit with that music. I'm sure some of us can remember it. Sorry? Exactly. And from what I heard, from nowhere, that music picked up, even on streaming platforms like Spotify, they were hitting the high top levels. And if that did not happen, that would have gone. So that is how, when you share knowledge, it can be revitalized. And the only reason why that happened was, I understand, the music was available. It was for use on that platform. And of course, he said he obtained permission from the family. So he wasn't violating any copyright. Somebody asked the question whether if content is available online, does it mean no? There are rules and regulations that govern that. It doesn't mean that when it's available online, it's free to use. So in any case, that's about information. So that is the natural state of the public domain. Inherently, information needs to be free. But it leads to what we call the tragedy of the commons, where you have something that belongs to everybody and belongs to nobody. So what do you have? People take and they don't replenish. At the end of the day, that resource dies. So if you leave knowledge, information in its raw, inherent, natural scope of the public domain, eventually it will die off. So there was need to privatize parts of that domain in order to encourage creation of value, because nobody wants to create a work only for somebody to go and make use of that work without any form of recognition or reward. So what you will have circulating is trash knowledge, prime knowledge, high quality knowledge will not be in abundance because the incentive to produce that is not available. So there was need to propertize parts of that public domain in order to create incentives for creation of valuable knowledge. However, it was also recognized that based on the characteristic of knowledge as something that desires to flourish, we cannot propertize the entire domain of knowledge. They had to create a space that is available to the public, where the public can also gain access. And there are some, like I said, I wanted to be very practical, but again, I can't help referring to some fundamental considerations, like the fact that nobody creates for nothing or from nothing. We all do what we all piggyback on the knowledge that was left behind by the previous generation. The only thing we come out from our mommy's tummy is with a cry. That's the only thing we know when we come out. Every other thing from that stage is, learned either by observation or by experience, by experience through the five senses. That's what we are saying, what we are hearing, what we are feeling, what we are tasting, what we are smelling. That is the accumulation of that forms what constitutes us as a human being at the stage in which we are formulating the idea to create. So whatever we are creating is coming out of the totality of our experience as a human being. And we cannot take full credit for that. We have to also give credit to the society through either formal, informal learning process, through either domestic or external processes like schools, through so many other processes. So there is this rationale that, okay, we have to also give credit to the society for that. Because if the society did not avail us with the abundance of the experience that constitutes the totality of our knowledge from which we have derived our inspiration, we wouldn't have been able to create. But more important was the concern of access. Because if we don't have access to knowledge, we cannot create. We cannot innovate. Innovation will actually die off. So eventually, there will be death of knowledge. So on those basis, the law had to consider from protecting or creating a space for people that create works to enjoy, to proprieties their effort, and also creating a space for the public. And how did he create that space? That is what I refer to as the constructed public domain. And that's what I'm talking about. I'm talking about the constructed public domain. And when I talk about the constructed public domain, I'm talking about intellectual property rights. And it's not only about copyright. When we talk about the public domain, it's not limited to copyright. But copyright is the space where it is most. Outside copyright, we also have other branches of intellectual property where the public domain is very important. In fact, if you talk about the area of innovation, where it affects health, concerns, innovations in health, agriculture, the public domain is very strategic in those spaces. So that is the public domain we are talking about. It is actually a constructed one. Now, what are the mechanisms that the law used to construct? Basically, the law used what we call limitations. So in as much as it recognized that people that create deserve some kind of reward because they need to be encouraged to create more. If we don't encourage them, creativity will die. Now, they said at the same time, we have to limit the scope of that power. Because if you allow them, if you allow creators, they will not want anything for the public, except that in the digital space, even the concept of openness became even more reinforced because digital technology itself is built on that concept of openness. It's hard to hide anything in the digital space, and it's very easy to share. Some of us are coming from the tech background. We know how easy, even practically, how you share things online, put on your spaces on social media, and it's out there. So even the digital space in which we are operating reinforces the fact that information needs to be open. So, but even before that, the law had also recognized, and so it created some of those spaces. And it says that, okay, yes, we have given authors a table, a rich table from where they can gain some kind of benefits for their work, either by using it directly or by granting permission for their work to be used. And in the process of granting permission, they also earn money. But as much as we are doing that, we're not going to allow them everything. They have to allow some crumbs to be falling to the ground, and they are not supposed to go after those crumbs. That is the space for the public. That is part of the public domain. So what are those crumbs? The limitations, what we call the limitations. And these limitations address the fact that it is not all kinds of works. Now, I'm talking specifically about copyright. It's not all kinds of works that are covered by copyright. There are some certain kind of works that the law says you can never claim copyright over this, no matter your effort. You can't. And the law does that to also enrich the public domain. We have things like ideas. The law says you cannot never claim any kind of protection over an idea. Maybe you can go to patent to do that, but not under copyright. Now, remember I said I'm talking about copyright now. Then processes and emblems like national anthem. The law says there is no copyright over such works. So that alone is a space for the public. Any kind of work falling under those categories belongs to the public domain. Now, it went further and said, okay, I have identified the areas that you don't have any claim over. But even on these areas that you have a claim, it's not everything that you can control, mind you. It's not everything. That's what the law says to authors, creators. When I say author, I am just using a generic word to cover all kinds of creative people. It says, okay, you can claim copyright over your book, But it's not every use of your book that you can control. There are some uses that you will not control. That is what we refer to as exceptions. So the limitations actually cover the scope of the subject matter, some kind of works that can never come under copyright. But the exceptions cover some kind of rights that you cannot enjoy even if you have copyright. Besides that, there's also the term limitation, duration. Now, any work that expires based on the terms of the law says what? 70 years plus the life of the author. So if you calculate that, at the point where you hit the mark, that work no longer belongs to the author. It now goes, or it enters into the public domain. So that constitutes part of the public domain. Now, for purposes of exceptions, it excludes personal use. For instance, you can use a work for your personal use purpose. When we say personal use, private use, it means it's not for commercial purpose. You can use it for private study. It provides exceptions for libraries, so that libraries can make use of works in certain ways that help their clients. For instance, they can make backup copies, but it doesn't allow them to make digital copies. If they want to digitize their collection, the law says that right belongs to the author, and you have to either ask the author's permission and maybe pay for it. Now, outside all of that, you can also decide to donate your work to the public. For instance, most of my publications are in the public. Now, copyright it does not specify that as part of the terms and conditions of copyright, but then it also does not disallow it. So you are allowed to do that. So basically, what is the public domain, the constructed public domain as defined under the law, is the public domain refers to all those works that are either not within the subject matter of copyright protection or are within the author, are within, but the author is limited as to how he can control certain rights, or works that are covered but are donated to the public domain by the author. And there are ways, easy ways of doing that. How? By using what we call the open licenses. So that is the best way I can explain the public domain to you, and I hope that you have the picture. So now I'll now go to the next slide. Importance of the public domain. I think I've talked about that a bit. When we look at specific sectors or industries, we see how relevant the public domain could be. Talk about education, for instance, because the public domain, as we have explained, is a reservoir of knowledge that you can easily access. Mind you, easily access. It doesn't mean that it's in the public domain, you can access it. There could be barriers. One of the barriers is technology itself. So if somebody takes a work from the public domain and locks it up somewhere, and you need some kind of encrypt the work, and you need some kind of permission, digital permission, that is a barrier. So the fact that the work is public doesn't mean that it is accessible. So there could be barriers. Now, it's a domain where you can easily access works for free without requiring to pay or seek the author's permission. It has a lot of value. Like I said, it encourages innovation, because imagine you want to study for medicine and you don't have access to textbooks. How do you go about it? You need access. So it provides access. And sometimes it's very, very expensive to access these things. So, but when we have enough allowances in our law, which allows us to make use of those kind of materials freely, then it's very helpful. And we have means of doing that. We have the open licenses, where some materials are published under Creative Commons license. So when you have such materials in abundance, they contribute in boosting or enriching the public domain. So it's very important for access to education, for innovation, and for creativity, cultural development. I've talked about the example of the Mike Ejara. You can imagine the kind of revitalization that emerged from that singular purpose, and even the value that came to the artist himself. Because this is an old man that was almost forgotten. Like, even from my generation, most of us don't really remember him like that. It now became a trend for younger generation. So that's the kind of cultural development, preservation. And we can look at it in different contexts. Apart from a singular person, we look at it from our cultural background. You have to preserve culture. There are some cultures that are being revitalized and made useful for the younger generation in their old form. Maybe they are not useless. Our younger generation, somebody like my daughter will not identify with some of those cultures, but the way they are being transformed and revitalized, it makes meaning to them, and they can actually have very good experience with that kind of culture. So it preserves culture. Even in music, we have a lot of musical derivative works that are allowed under the exceptions, maybe because they are kind of they have a social value by being social criticism. They are not necessarily for commercial purpose, but to criticize, maybe make fun of politicians, criticize, high society people. They have some social value. Those kind of works, the law allows people to make use of. And when you see, especially if you go to social media, you see young people recreating some of these works. Maybe somebody like recreating Fela just to criticize politicians. It's allowed. So those are the spaces that our law allows for the public domain to flourish. So what are the policies and laws that can help in enriching the public domain? For law, I think, like I've said, the law is already very expansive in that regard. The law has provided spaces for the public domain to flourish. So I would say that our law is relatively comprehensive, but there's always room for improvement, especially when we're talking about the new technologies, especially when we talk about things like generative AI, where you require large volume of information. Now, the exceptions as one of the areas where the law allows the public domain to flourish, are they enough to cover people in the library? Are you allowed to transform works into digital forms in a way that, to the volume that is required for things like AI development? I don't think the law allows you that. It allows, maybe if it's for non-commercial purpose, but a lot of times most research are funded. So our law is not robust enough in that area. So if we're thinking of legal reform in future, maybe that's the area to look into. But that's a long-term consideration, looking at the dynamics of Nigeria. So the shorter term and maybe low-hanging fruit is to go through policies. And again, I think our law is robust enough to support policies, especially when we have recently come up with an intellectual property policy framework. Now, so institutional, when I say institutional, I'm referring to policies. We have a number of policies out there, which I will not even go to them individually, but on the whole, they align with the concept of the concept or idea of an open space. They encourage openness in information. So we can see that our policies are aligned towards that. But the question is, are they enough? We have, for instance, the open access policies for Nigerian universities. Many Nigerian universities are adopting that. In my institution, for instance, all our journals are published open access. So you can access our journals. Once you go to the link, you can open them and access them. So that's what most institutions are doing, the universities. And that is a way of enriching the public domain and encouraging access. Now, we have policies like the National Policy on Open Education Resources that was adopted in 2017. And if we know about open education resources, it's just a policy that says education materials should be produced in a form that they are open and can be shared freely. So there shouldn't be inhibitions. And mind you, when we talk about some of these open strategies like licenses or models, for instance, open educational resources, it doesn't mean that they turn their back to copyright. They flourish because of copyright, because they already recognize that the authors and creators of these materials have copyright over those materials. But all they are saying is that those materials must be published in a form that they can easily be accessed. And how do you do that? By using some of those open licenses. One of them is like the Creative Commons license. And when you want to talk about software, we talk about open source software. So the fact that you're using a free material online doesn't mean it doesn't have copyright. And so even if you're using a Creative Commons license, you still need some kind of authority from the author. And without that, of course, the license will state it. So once the material is published with the license, you can easily know what the author wants you to do with that work and what you cannot do. But no matter what you are allowed to do with that work, you must always attribute the author. That tells you that in every situation, copyright remains steady. Very, very important. So you don't go online and see somebody's material. The fact that nobody is coming after you doesn't mean that you're doing something right. One day, monkey go market, no will come back. So, yes, okay. Now, like I said, we have these policies. They are very, very encouraging, but are they enough? For us to understand whether they're enough, we have to look at best practices, what other countries are doing. And we see that other countries are more intentional. They are more strategic. It's not just about making general policies. They are very, very intentional and specific about them. For instance, you have the EU Open Data and Public Sector Directive of 2019, which deals with reuse of public sector information. It requires EU member states to ensure that publicly funded data and cultural resources are open and reusable. Now, you have these different policies and practices, but one of the things that stands out in most of these countries is a clear recognition of open licenses. It is clearly recognized and mandated, especially for government-funded research. So the government itself recognizes open licenses like Creative Commons licenses. And so even in the government publications, most of them, based on those policies, they are published with Creative Commons licenses. So that's the difference. Nigeria, the use of Creative Commons license is currently operational in Nigeria. It's ongoing, but there is no mandatory policy towards that. It's based on whether you like it or not, or whether you're inclined to use it or not. But there is no clear mandate on that. So that is what we lack. If we recognize that open licenses are very important based on the fact that public domain is important, and we also recognize that respecting copyright is also very important, then we should recognize things like Creative Commons licenses. There should be government policies towards that, mandating institutions to use these licenses, especially when they are publishing research output that were funded by the government. Maybe when we talk about the private sector, that may not be so, but when we're talking about the public sector, where they use taxpayers' money to fund research, I think there should be a mandatory policy on the use of Creative Commons licenses. So, talking about actions elsewhere, we have what we call orphan works. I don't know whether we know what orphan works referring to. These are works that don't have any parents. They are orphan. Why are they orphan? Because most times you can't identify the authors. You can't identify. And in a country where things really work very well, in some of those orphan works, you think that there's no owner. But suddenly, maybe you use it in a certain way and then it blows. then you see that there is an owner. They will come for it. So in societies where the law functions very well, people will not even dare. And so they have policies that clearly make exceptions for the use of orphan works. So that if you can follow those conditions that are laid down in the law, you can actually use orphan works. For instance, you must have made very serious efforts to locate the author, but you were not able to. So in that case, you can go ahead and use the work, provided you can prove that you actually made efforts to locate the author. But we don't have any, our law does not contain that kind of provision. We have the, so you can always, can I say something? He supervised, like he examined my PhD thesis. Yes, he's my external examiner. Thank you, sir. I still have to appreciate you in a very other way, but let them know that my PhD has authority. Okay, so that was by the way. So if I'm saying anything that is not very correct, he will just correct me here, because we are still in the examination process, and then we are all here to learn, okay? Nobody knows everything. So we don't have very clear provisions on orphan works in Nigeria. I think that's an area where the law can improve also. So challenges, what are the challenges we have? Yes, we have all these policies, we have the law. I've said the law is relatively enough to do the job. But what are the weaknesses? Institutional coordination. Madam DG from, DG, National Library, she talked about, people have talked about how institutions are not able to cooperate because there is no clear directive to guide them. So those are some of the weaknesses. Institutions are supposed to do something, they can't do it because they are incapacitated in one way or the other. We have low awareness. A lot of times, I am an advocate for open licenses. Part of my research is based on that. I am the country lead of Creative Commons Nigeria. I've done a lot of voluntary work in that regard. So a lot of times, even amongst my peers, even in my community of scholars, people don't want to hear about Creative Commons license. How can I spend time and money, invest to produce an article, and then you want to go and publish it for free? People will just go and be sharing it, downloading. How do you do that? No, we'd rather publish where we can maybe get some kind of compensation. So even in my community, where you don't really need, you can be compensated in different ways. By way of tenureship, for instance, my promotion is based on how many publications I have. So, and then also visibility. You can actually gain by more visibility, but they don't want to hear that. Creative Commons comes with a kind of negativism attached to it. So we need a lot of awareness, which is why I commend Free Knowledge Africa for the initiative they are taking, and that's why I have always identified with them. Fragmented IP and data policy, I listed out some policies, but when you look at them, where is the coordination? Where is the coordination? There is actually no coordination. A lot of times there are even overlaps. Limited digital structure, yes. Sometimes you're struggling to download the material, it takes you ages. You can't do that because of low connectivity. That's an issue. That's a very, very big issue, especially for people that work online. You want to download an app, it takes you forever. So it is a critical problem. Even, like I told you, the fact that the work is available in the public doesn't mean you can access it. There are barriers. So if you have the work in the public and you cannot download, what have you achieved? So it's a weakness. Suggestions for reform, where I've said legal reform is a long-term goal, whether it will happen, whether it can happen. But if at all it should happen, it should be in, again, that is almost an impossibility. But I know that currently some countries are beginning to debate about lowering the copyright terms, because right from the time copyright law was discovered, the term of protection keeps going up, never down. So they're beginning to think maybe that it's time to lower it because of how the digital technology transforms every rationale that was behind copyright law. The digital ecosystem encourages sharing. So if we continue to increase, okay, take for instance Chinua Achebe's book. Chinua Achebe died at the age of quite an advanced age. His copyright was valid up to when he died. Sorry, forgive me, I can't remember when he died. But let's assume he died in the year 2000. So you start counting from the year 2000 to 70 years before. By then, most of us that needed the work, we too would have joined queue now. So some people are beginning to tinker with the idea. I think it's time to lower the term, but would that happen? Because the argument on both sides are strong. There are strong institutions pushing also for longer terms because of what they stand to benefit, and those people seem to have more power than people that are advocating on the other side. Then introducing clear provisions for orphan work, that could be for law reform, but for policy, I've said there needs to be more coordination, increased awareness, and things like that. Then these are some specific policies I've talked about. I've talked about publicity, creating awareness, digitizing. So governments, especially for this, remember I said there are some works that are open but not accessible. What stops government institutions from digitizing those works and making them available? That will further help to boost the public domain, encourage the use of Creative Commons licenses, have a national public domain repository. When I say repository, I mean an open space where people can actually dump their publications, and then it's open to the public. But that should not be based on sectoral institutions like educational institutions. It should be a general institution that covers all kinds of works. Adopts an open access policy. Publications, Nigerian journals should be encouraged to publish by open access. Open access is another model of openness that allows works to be accessible freely by the public. So government should encourage that, especially in government institutions like federal universities and so on. Those are policies that, low-hanging fruits that can be done, and then we'll have an enhanced, enriched public domain. Thank you very much.
Thank you so much, Ma. Thank you. So please, do we have any question for her before she have her seat?
You mentioned intellectual property. So I want to ask, do all countries have the same rules regarding the intellectual property rights? Then the second one is, can a work be in public domain in one country and be copyrighted in another country? If I derive a film from a literary work, who owns the copyright? Supposing if I decide to put my film in the public domain, what happens?
Okay, thank you very much. 3 questions. Whether the standard of copyright, intellectual property, whether it's the same globally, and whether a work that is in public domain in one country is also public domain in the other country. Okay, let me speak to those 2 questions first. First of all, intellectual property standards are not the same globally, but they have what they call minimum standards established by international intellectual property conventions. So once a country's law meets those minimum levels, then they can go any direction they want to. They can always go up, but they can never go below those minimum standards. So on that basis, intellectual property laws are not the same globally. Now, whether a work that is in the public domain in one country is also in the public domain in another country is also not the case because of the different standards. So for instance, term limited duration. If a country provides for 50 years instead of 70 years like Nigeria. When it's 50 years time post the death of the author, that work will enter into the public domain in that country. But in Nigeria, the same work will not be in the public domain. And again, that depends on whether that particular work can be covered under Nigerian law. Because before a work becomes copyrightable in Nigeria, there are conditions. For instance, you have the location or connecting factors. The work must have been published in Nigeria, and the author or the writer is resident in Nigeria. So if the work does not satisfy those basic conditions, then it doesn't flew off my head. Okay. Now, if you derive a film from a copyrighted work, the first question I want to determine is whether you had the permission of the owner of that first work to make that derivative. So let's assume that you did, you had his permission. Then certainly your own work also enjoys copyright because it's an independent work from the original one. Now, if what you did was to copy that work from the public domain, it depends. Whether you will enjoy copyright depends on two things. Number one, whether you copied the work verbatim. So for instance, maybe you come across an old story or an old book or something which is no longer in circulation. You now reprint that book, maybe change the cover, but the content remains the same. You cannot claim any copyright because you have not created anything new. So you have just helped us to bring it back to circulation. But if in the process you made some adjustments, then you can now enjoy copyright.
It is just bad that people should reap what they did not sow. By people copying in whatever way other people's intellectual property. Now I want to ask, is there no way that the security establishment can be strongly involved in checking this malice? Thank you.
Thank you very much. Of course, why not? The security is already involved. The only question is whether they are being effective. But the security is already involved because when we talk about copyright, we are talking about protecting property. And what's the duty of the police? To protect property. So the security is already involved. And even the NCC itself, which is the administrator of the copyright sector in Nigeria, they have some role to play in terms of security, in terms of providing enforcement. They have some role to play. And they work in collaboration with the police. So, for instance, they can storm a warehouse where it is suspected that pirated works are stored, or an industry or company or building where it is suspected that pirated works are being produced. The custom is there to intercept pirated books from being imported or being exported. So the security people are already involved, and I think they are trying their best, but we know Nigerians, human beings are smart, and it's a thing of being one step ahead of law enforcement. So no matter how you try, there are some people that will still be able to get away with it. But the security people are actually making effort. You have the custom, you have the police, you have the NCC also involved.